Go.
Welcome to the 2015 Lone Star Classic. Today is Saturday, October 17th. We are at St. Mary's School of Law in the law school courtroom. Today's case is State versus Rollins. It's a case about a businessman who was shot in the back by his second wife, Cinnamon Rollins, and we'll get ready to proceed in just a few moments.
Please be seated.
Hello and welcome everyone to the 2015 Lone Star Classic hosted by St. Mary's University School of Law. Today is Saturday, October 17th, 2015. We're about to begin the final round of this competition. Today's problem is State versus Rollins, a murder case involving a marriage complicated by an unusual mental disorder. I am delighted to introduce our distinguished panel of judges. As presiding judge today, we have the Honorable John W. Promomo, Magistrate Judge for the United States District Court for the Western District of Texas. Judge Promomo is a distinguished graduate of St. Mary's School of Law and has served as a United States Magistrate Judge since 1988. He also serves as co-director of Camp Discovery, a summer camp for children with cancer. We also have Richard Durbin, U.S. Attorney for the Western District of Texas. Richard has served with the U.S. Attorney's Office in the Western District since 1983. Richard obtained his Juris Doctorate from the University of Texas School of Law in 1980, graduating with high honors. He is an instructor at the National Advocacy Center and has taught as an adjunct professor at St. Mary's School of Law. Serving as our representative from the defense side, we have Ms. Donna Colthorpe, Deputy Federal Public Defender for the Western District of Texas. Ms. Colthorpe is one of our distinguished alumni graduating from St. Mary's School of Law in 1997. Thank you all. We are set to begin.
Good morning, Your Honor. Calling the case of State v. Rollins. My name is Benjamin Garmoe. My last name is spelled Garmoe, and I'm here today on behalf of the state.
Good afternoon, Your Honor. My name is Morgan Thomas, last name Thomas, on behalf of the state of Lone Star, and when Your Honor is ready, we do have housekeeping matters and motions in limine for your consideration.
Thank you. Have the defense.
Yes, Your Honor. Good afternoon. My name is Nicholas Gurney. That's Gurney, and I'm joined by my co-counsel,
Kerwin Mike. That's Kirwinn for the record, the first name.
and we represent Mrs. Cinnamon Rollins in this case. Mr. Mike has a copy of our notice of appearance for Your Honor's reference and a clean copy of the record for Your Honors if you'd prefer.
Counsel, the prosecution, you indicated you had a pretrial matter you wish to address.
Yes, Your Honor, we do have some housekeeping matters to address with the court. First of all, Your Honor, may we have permission to move freely about the well of the courtroom?
Yes.
May we assume that all witnesses have been constructively sworn in for the purposes of today's trial?
Yes.
Pursuant to Federal Rules of Evidence 615, may we assume that all witnesses, excluding expert witnesses and party representatives, are constructively sequestered for today's trial?
Yes.
May we assume that all sidebars, when they are requested, are made constructively outside of the presence of the jury?
Yes.
And may we remain at counsel's table when we argue those sidebars?
Yes.
Now, Your Honor, seeing as we do not have a bailiff in today's case, would it be amenable to the court to keep admitted evidence at the bench in front of Your Honor?
That will be fine.
Your Honor, would you like us to ask permission before we approach the witness and the bench?
That will not be necessary.
Yes, Your Honor. That does conclude our housekeeping matters. Ms. Thomas does have 3 motions in limine for your consideration.
Just one housekeeping matter for the defense, Your Honor. Due to the unique rules, the unique local rules, we'd ask permission when necessary to enter evidence on cross-examination, as we're not entitled to any rebuttal case.
That'll be fine.
We're ready to move into motions in limine.
All right. Go ahead, sir. Oh, you have a motion in limine first?
Yes, Your Honor.
Go ahead.
As Your Honor may be aware, the defendant, Cinnamon Rollins, is on trial for the murder of her husband, Charlie Rollins. On February 14th, 2015, the defendant got into a heated argument with her husband, and that argument ended with the death of her husband. Now, during our case in chief, the state intends to offer a photograph of the victim as he was found on February 14th, 2015. I can publish on the overhead for Your Honors.
Not necessary.
Your Honor, our first motion is to be able to use the technology and the picture of the victim as he was found during opening statements.
Defense would object as a lack of predicate, lack of foundation. We don't know that this evidence will be admitted, and certainly the defense will have objections at the time of its admission, and to allow it during opening statements would be premature.
Do you know what your objections would be during trial, counsel?
Yes, Your Honor. If Your Honor would like me to lay them out now.
Please.
The use of the photograph under Federal Rules of Evidence 403 is substantially more prejudicial than it is probative, as it would prejudice the members of the jury. In this case, there's no dispute that Mr. Rollins is dead and that he died as a result of a gunshot wound. However, to show this photograph to the members of the jury would unduly prejudice them, as it would play on the emotions of the jury and inflame their passions.
The objection's overruled, and you will be able to show the picture during your opening statement to the jury.
Yes, Your Honor. State's second motion is to exclude any mention of a written reprimand that Detective Stevens received in 2013. Detective Stevens is the first witness for the state, and he is also the primary investigator for the death of Charlie Rollins. We move to exclude this evidence as it is not relevant. The written reprimand was in response to false travel claims that were filed, not on his credibility in any prior case or even in this case.
Your Honor, the evidence of Detective Stevens' fraudulent travel claims is relevant, as it goes to the credibility of the witness, and as Your Honor knows, all credibility issues are always at play in these trials. And additionally, under 608B, in the Federal Rules of Evidence, this is evidence that goes to the truthfulness or untruthfulness as to specific instances of conduct, and it was in the course and scope of Detective Stevens' work as an investigator, as a detective, and should be permitted in trial.
Motion in limine as to the detective is overruled, and that will be allowed into evidence.
Finally, Your Honor, state moves to exclude any expert opinion as to the mental state of the defendant on the morning of February 14th, 2015. Under Rule 704B, Your Honor, expert testimony or expert opinion is not permitted to go towards a primary element of a defense or a crime charged, and in this case, the crime charged is murder. Furthermore, we anticipate that a defense of self-defense will be put on, and mental state is a primary element of both of those charges and defense.
Your Honor, in this case, the court will hear evidence of paranoid personality disorder, a disease that Mrs. Rollins suffers from, and this disorder, the diagnosis of this disorder, will be presented by a Dr. Casey Prescott. This is permissible as it doesn't go to an essential element of the charge. It doesn't refute intent or knowledge, which are the elements of murder that the state is required to prove. And it won't prove self-defense either. It goes to her state of mind and what she perceived, in particular threats and the fear that she felt on that day. It goes to show that, and as a result, it's permissible as it's not implicating the ultimate issue rule that opposing counsel cited.
The motion in limine is overruled on that point.
Yes, Your Honor, we're ready to move to opening statements.
And counsel for the prosecution, because I was not really prepared, would you again tell me and spell your names, please?
Certainly. First name Morgan, last name Thomas, Thomas.
And your name, sir?
Yes, Your Honor. Benjamin Garmoe, last name spelled Garmoe.
Thank you very much.
Thank you.
All right. And did the defense have a motion in limine?
Yes, Your Honor.
All right.
Under Federal Rules of Evidence 702 and 403, the defense moves to exclude the crime lab report. It's located on page 74 of the record. Your Honor, this is an improper opinion and thus confusing to the jury.
Your Honor, this forensics report that counsel is referring to has been stipulated to be authentic. So it is self-authenticating in today's trial. It can come in without foundation being laid from any specific witness. We can proffer that we will be using this report for Detective Taylor Stevens to communicate how the report affected his investigation. He's not going to be offering any expert testimony, and it has been stipulated by both parties that the information in this document is in fact authentic. So there are no improper expert opinions that are at issue here, nor are there any foundational problems.
The motion in limine on that point is overruled.
Your Honor, may I be heard on that?
Briefly.
Your Honor, authentication does not equal admissibility here. We're saying that this is expert testimony. This crime lab report is expert testimony. And in order for it to be admissible, it must follow the prongs under 702. This does not. This crime lab report is conclusory.
The motion in limine is overruled.
Your Honor, under Federal Rules of 802, the defense moves to exclude the journal entries that are located on page 63 through 66. Your Honor, these are entries of Charlie Rollins, and these are hearsay. It should not be admissible.
Your Honor, under Federal Rules of Evidence 807, information can come in for its truth when in fact it possesses circumstantial guarantees of trustworthiness, and to admit the evidence would serve the interests of justice. As Your Honor is aware, these journal entries that counsel are referring to are the spoken or the written declarations of Charlie Rollins for the past 7 years before this incident occurred. The nature of these journals and the knowledge that they are in fact authentic suggests that they have circumstantial guarantees of trustworthiness under the totality of the circumstances. And given that Mr. Rollins is not available to testify today due to his untimely death, this serves the interests of justice in that the jury will be able to hear his voice. Additionally, Your Honor, this will contradict some of the testimony that will be offered today, the words of the defendant, Cinnamon Rollins. So it has probative value under Federal Rules of Evidence 807 and should be allowed.
The motion's overruled.
Yes, Your Honor, defense is ready to move to opening statements. We would also ask if we can use the picture of the unsheathed knife on our opening statement.
Any objection?
No objection, Your Honor.
All right. Court will recognize the prosecution to make its opening statement.
May it please the court? Counsel, members of the jury, she shot him in the back and she's running out of stories. This case is about the defendant, Cinnamon Rollins, who on the morning of February 14th, 2015, her 5th year wedding anniversary, did this to her husband. She shot him in the back. Now, Miss Rollins sat in her house, and she came to Detective Stevens after she did this to her husband. Now, as you'll hear today, members of the jury, Miss Rollins came to Detective Stevens, the primary investigator in this case, not once, not twice, but 3 separate times. And each time, she had a different story about what happened that morning. Good afternoon. My name is Morgan Thomas, and along with my co-counsel, Benjamin Garmoe, we represent the state of Lone Star. Now I want to take a moment to tell you about the defendant, Cinnamon Rollins. She's a young, smart, and savvy woman who knows what she wants and knows how to get it. And as you'll hear today, members of the jury, when she first met Charlie Rollins, he was married. But she wanted him, and as you will hear in the end, she got him. Now, over the course of this marriage, Miss Rollins realized that there were certain things about her husband that she just did not like. The first thing that you'll hear that she didn't like about her husband was the fact that he would flirt with her employees. You'll hear about one employee in particular today. The second thing that you'll understand that she didn't like about her husband was the fact that he would hang out with other women without her. And the third thing that you will hear that she did not like about her husband is that he would keep pictures of his first wife all around their house, even in the bedroom that they shared together, in the home that they bought together when they first got married. Now, as the state, it's our burden to prove to you beyond a reasonable doubt that the defendant, knowingly or intentionally, walked into her house the morning of February 14th, walked up those stairs, reached into the dresser drawer, pulled open the drawer, got out the revolver, and shot her husband in the back. And we will do that through two witnesses. The first witness is Detective Taylor Stevens. Now, Detective Stevens is an experienced homicide detective with 4 years of experience. Detective Stevens has worked on 35 cases, and he will tell you that he had an opportunity to talk with Miss Rollins. She gave not one, not two, but 3 different accounts of what happened that morning. At first, she said she didn't remember exactly what happened. The second time, she said it was an accident. But that third time, when she came to hear Detective Stevens, she said that she had to act in self-defense because her husband came at her with a knife. But Detective Stevens will also tell you today, members of the jury, and you will see that the physical evidence does not corroborate that, as the knife that was belonging to Charlie Rollins was sitting on the dresser, still covered in its sheath. Now, you'll also hear from Dr. Alexis Crawford. And Dr. Crawford is a board-certified psychiatrist. And Dr. Crawford will tell you that he also had an opportunity to sit with the defendant, and that she is of sound mind and is not suffering from any mental illnesses. Now, at the end of today's trial, my co-counsel, Benjamin Garmoe, will come before you. And he's going to review all of the physical evidence with you and all of the testimony. And we believe that we will firmly convince you that Ms. Rollins knew exactly what she was doing that morning. She waited for the perfect moment when her husband turned his back, and she fired that one shot that killed him. And at that time, when my co-counsel comes before you, we ask that you find the defendant guilty. Thank you.
Court will recognize the defense to make its opening statement.
Yes, Your Honor. May I inquire?
Yes.
Life or death? That's what this case is about. That's what Cinnamon Rollins had to decide on Valentine's Day. The day her husband tried to kill her with a 12-inch Rambo knife, also known as a combat knife. Now, members of the jury, when Cinnamon Rollins returned home that morning, her husband was still fuming from an argument the night before. But this time was a little different. This time, he was waiting upstairs in his bedroom with that 12-inch combat knife sitting out of the drawer on the dresser table. And when she returned home, they got into one last argument. And that's when Cinnamon Rollins hears her husband yell the words, "I'll fix things forever," reach and grab that Rambo knife and lunge at her, trying to kill her. This Rambo knife. That's when she had to make a decision. That's when it was life or death. That's when she remembered all the times he abused her, threatened to kill her, shook her. So she grabs the gun. The gun her husband bought her for protection. And she chose life. She chose to live. Now we're here today because the government, they're calling this murder. And they have to prove beyond each and every reason about that this is murder. And they also have to prove beyond each and every reasonable doubt that Cinnamon Rollins didn't try to defend herself that day. That it wasn't self-defense. But what the evidence will prove to you today is that it was life or death. Members of the jury, I want you to pay close attention to 3 key facts here today. 1, Cinnamon Rollins suffers from a disease, a mental health disorder called paranoid personality disorder. 2, because of this disease and the mental and the aggressive acts of her husband, she was in fear for her life. And 3, because she was in fear, she had to defend herself. Now let's talk about paranoid personality disorder. Today you're going to hear from a behavior expert, Dr. Casey Prescott. He's going to come to this stand here today, and he's going to talk to you about paranoid personality disorder, or PPD. He's going to tell you what it is, how it works, and how it affects Cinnamon every day of her life. He's going to tell you how it's comprised of a combination of life experiences, like when Cinnamon was 10 years old, she found her mother face down in the family pool, dead. Or how she persistently bears lifelong grudges against her sister. Or how she can't even speak about her parents. Dr. Prescott will tell you today that these life experiences manifested itself in Cinnamon Rollins' adult life, accusing her employees of stealing, suspecting her husband of cheating, can't even establish friendships because she feels as if every woman is out to take her husband away from her. All unjustified to a reasonable person, but this is a reality of Cinnamon Rollins. Dr. Prescott going to tell you that because she suffers from this disorder, this disease, it was consistent with her belief that her husband tried to kill her on February 14, 2015. Which leads me to my second point. Because of this disorder and the aggressive acts of her husband, she was in fear for her life. Now, members of the jury, today you're going to hear evidence about Cinnamon Rollins' marriage. And though it gives me no great pleasure to speak ill about the deceased here today, you're going to hear how he was abusive to her, how he threatened her, how he threatened to kill her, shook her, told her to stop imagining things, get a grip. You're going to hear how he didn't know how to cope with Cinnamon Rollins' disease, wondering where she comes up with these things in her head. You're going to see how his anger slowly started to build. From not trusting her, to threatening to divorce her, to threatening to kill her. You're going to see how these aggressive acts affected Cinnamon Rollins, someone who's already suffering from PPD, how it heightened that fear. Which leads me to my third point. Because of this fear, she had to defend herself. Members of the jury, you're going to hear it was self-defense. Her husband lunged at her with that combat knife. Today you're going to hear from Detective Taylor Stevens. And today you're going to learn that he heard of this abuse. He heard of the fear. He heard of self-defense. And he chose not to investigate any of it. You're going to hear from the beginning he was at a disadvantage, working the investigation alone without his partner. You're going to hear how emergency personnel was there before he was, already inside the house, in the bedroom. Detective Stevens will not be able to tell you today what that house looked like before he arrived. But you will hear how he learned of this fear, and he chose and he failed to investigate it. But today, the failure stops here in this courtroom. Today, the evidence will show you it was life or death, and Cinnamon Rollins chose to live. And at the end of this trial, my co-counsel, Mr. Nicholas Gurney, he's going to come before you. He's going to go over all the evidence. And he's going to ask you for a verdict. The only verdict that this evidence supports. Not guilty. Thank you.
Prosecution can call its first witness.
Your Honor, before the prosecution calls our first witness, we would seek to admit into evidence states 1 through 3. May I approach defense counsel and the bench in turn?
Yes.
Your Honor. Sorry.
Your Honor, states 1 through 3 are the medical examiner's report, the forensics report, and the death certificate. They are self-authenticating under Rule 803.6. They are an exception to the hearsay rule, and they do have certificates that confirm both their authenticity and their chain of custody under Federal Rules of Evidence 902.11. So we move them into evidence at this time.
Your Honor, we do not give a hearsay objection here, but we do have a 702 objection, Your Honor, that it's an improper opinion, just like Mercer and Lemon, Your Honor. Also, Your Honor, there is no report on how the methodology was used to come up to these conclusions and whether this facts and the methodology used was applied to this case. Your Honor, it's unreliable and would not substantially assist the jury, and they have not laid the proper predicate in order to get this into evidence.
The objections are overruled, and prosecution exhibits 1 through 3 are received independently.
Yes, Your Honor. At this time, the state seeks to read into evidence the 911 transcript that occurred on the day of February 14th. That's found on page 67 of the record. If it's amenable with the court, Ms. Thomas and I will read the 911 transcript.
Yes,
May I instruct the jury, or would Your Honor like to instruct the jury?
you may do so.
Members of the jury, at this time,
Your Honor, we object to this because it's hearsay. It's a 911 call.
May I respond?
Go ahead.
Your Honor, this statement, first of all, has been stipulated as authentic. The dispatch portions of this statement are questions and thus are not hearsay. The answers are admissions by party opponent as they were made by the defendant in this case.
You point to me exactly where you're referring?
Yes, Your Honor. This is on page 67 of the provided record.
Objections overruled.
Members of the jury, what we're about to read to you, what Ms. Thomas and I are about to read to you is a 911 call, a transcript that occurred on February 14th, 2015 at 10:15 a.m. Dispatch, what is your emergency?
Caller, I think I shot my husband. Please hurry.
Dispatch, is he still breathing?
No. Caller, no, of course not.
Dispatch, where are you now?
Caller, 161 Willow Glen, unintelligible.
Dispatch, what did you say?
Caller, please hurry. Call ended by caller. End of transcript. Your Honor, at this time, state calls Detective Taylor Stevens to the stand.
Witness has previously been sworn.
May I inquire?
Yes.
Good afternoon. Please introduce yourself to the members of the jury.
Good afternoon. My name is Taylor Stevens. That's spelled Stevens.
What do you do for a living, Detective Stevens?
I'm a police detective here in San Antonio with the San Antonio Police Department.
Where are you currently assigned?
I'm assigned to the homicide unit, and I've been there for about 4 years now.
How did you go about becoming a homicide detective?
Well, I graduated from San Antonio University with a Bachelor's of Science degree in chemistry. After that, I went to the police academy and graduated in the top 5% in my class. After that, I went to Quantico, Virginia for a forensic science education with the FBI.
What kind of coursework did you do there?
I was trained to identify pertinent and relevant evidence at crime scenes. I'm also trained to dust for fingerprints, collect DNA, and retrieve evidence and weapons.
Now, Detective Stevens, what does a homicide detective do?
Well, as a homicide detective, I investigate homicide-related crime scenes. Once I report to the scene, I secure the scene, and then I look around to collect evidence. And once I collect evidence, I submit them to the evidence lab. After that, my initial investigation at the crime scene is over, so I conduct interviews with potential witnesses and potential suspects.
Did you go through those same procedures in preparation for this case?
Oh, absolutely.
How did you become involved in this case?
I received a call from the dispatcher at around 10:15 a.m. on February 14, 2015. I was notified that a woman had killed her husband.
Where did you respond?
I responded to 161 Willow Glen here in Bexar County, San Antonio, state of Lone Star.
What time did you arrive?
I got there in the morning at around 11 a.m.
What did you observe when you arrived at around 11?
As soon as I got there on the first floor of the kitchen, I saw the defendant in the kitchen staring at the floor with the gun in front of her.
Now, I'm going to get back to that gun in a second, but do you see the defendant sitting in this courtroom?
Yes, I do.
Could you please identify her in an article of clothing?
Yes, she's sitting next to the defense counsel's table in a white blouse and a blue jacket.
And do you know the name of that defendant?
Yes, her
Who
name
is
is Cinnamon Rollins.
Your Honor, let the record reflect that the witness has identified the defendant. Now, you mentioned that there was a gun sitting in front of her. Did you ask her any questions about that gun?
Yes, I asked her if it was loaded. She said yes, so I immediately retrieved the gun.
What did you do after you retrieved the gun?
I looked around the house to collect evidence. I was known that a gunshot was involved, so I was looking for a body, a dead body.
Did you ever find one?
Yes, I looked around. I went upstairs and found a dead body in the bedroom, later known to be Mr. Charlie Rollins.
What else did you do in the bedroom?
As soon as I got there, I took a photograph immediately to preserve it for the record, and then I walked around the house to collect evidence, and I found a knife and a journal.
Did you take pictures of those things that you found?
Of course.
Would you recognize them if I showed them to you?
Yes.
Showing counsel what has been pre-marked as State's Exhibits 4, 5, and 6. What has been admitted as State's Exhibit. Detective Stevens, do you recognize these photographs?
I do.
How do you recognize them?
They're the picture that I took at the scene that I've just mentioned. There's a picture of the bedroom, the picture of the gun, and the picture of the knife.
And are those a fair and accurate representation of the body and the items you collected on February 14th, 2015?
Yes, they are.
Your Honor, State moves Exhibits 4, 5, and 6 into evidence.
No objection, Your Honor.
Exhibits are received into evidence.
Permission to retrieve from the witness and publish for the members of the jury. Could you please instruct the court tech to change the screen? All right, Detective Stevens, I'd like for you to look at State's Exhibit 4.
Certainly.
Oh, what do you notice in this picture?
Well, this is what I saw as soon as I got to the bedroom. If you see right here, there's a dead body right there. That was Mr. Charlie Rollins. Right in front of him, there's a knife right there that I took a picture of also. And right here inside the dresser, I also retrieved a journal.
Okay, could you erase all of those markings?
Certainly.
Now moving you to State's Exhibit 5. Why did you take this picture?
This is the gun that I retrieved from the defendant in the kitchen.
Could I move you to State's Exhibit 6? Why did you take this photo?
Oh, this is the I took this photograph of the knife that was on the stand. This is how I saw it when I got to the scene.
What did you notice about the knife that made you want to take a picture of it?
If you pay close attention to the knife right here, it's actually clothed in its sheath.
What is a sheath?
Sheath is what covers the knife. It's what houses the knife so that you can keep it in safekeeping and that no one will get hurt.
Now, after you took these photographs, what did you do?
I immediately submitted the evidence to the evidence lab, and I had the dead body transferred to the medical examiner for a medical examiner's autopsy report.
Now, were those tests detailed in reports, all of those tests?
Yes.
Could I retrieve State's Exhibits 1, 2, and 3? 1, 2, and 3. Thank you very much. Detective Stevens, do you recognize these documents?
I do.
How do you recognize them?
They're the reports that I reviewed from my investigation. They're the autopsy report, the death certificate, and the forensic report.
And are they in the same or substantially the same condition as when you previously reviewed them?
Yes.
Now, Detective Stevens, I want to go through each of those reports at the time. Let's start with the medical reports.
Yes, the medical reports of the death certificate and the autopsy report reflect similar information. It confirms that Mr. Rollins was in fact dead on February 14, 2015, and it also reflects that his approximate time of death was at 9 o'clock in the morning, which is about 2 hours before I got there. Also, it specifies that the wound that Mr. Rollins sustained in the back was consistent with a .38 caliber gunshot wound.
Now, what about the forensics report?
The forensics report reflects the testing that were done on the bullet, the gun, the knife, and the journal.
Let's go through those one at a time. Start with the bullet and the gun.
Yes. The bullet that was retrieved from the victim's body was in fact a .38 caliber bullet. It was an exact match to the gun, which was a .38 caliber Smith & Wesson single-action revolver with a laser sight that was attached to the gun.
How do you know there was laser sight?
It was reflected in the report.
So let's talk about the knife.
Yes. There were fingerprints examination done on the knife. The knife had 2 fingerprints on it. The fingerprints belonged to both the victim and the defendant.
Now, you mentioned there was a journal.
Yes.
What about that?
We dusted for fingerprints for the journal as well, and we found both the victim and the defendant's. The defendant's fingerprints were found on the covers and the last 5 pages of the journal.
Now, did you ever have an opportunity for a search warrant in this case?
Yes, we obtained a search warrant successfully for the journal to recover the journal that was in the dresser. It was successful, and I retrieved it and reviewed the journal entries myself.
Now, you reviewed those entries. Would you be able to recognize them if I showed them to you?
Certainly.
Showing you what has been pre-marked for identification purposes only as State's Exhibit 7. Do you recognize those documents?
I do.
How do you recognize them?
These are the entries that were made in the journal that I retrieved.
And are those entries in the same or substantially the same condition as when you previously reviewed them?
They are.
Your Honor, State moves Exhibit 7 into evidence.
Your Honor, we renew our motions of limiting objection to this as hearsay.
The objection is overruled and the exhibits received into evidence.
Now, Detective Stevens, what information was important to your investigation in those journal entries?
Well, the majority of the journal entries talked about Mr. Rollins, the victim's mourning for his first wife. And towards the end, it talks about how Mr. Rollins got to meet Miss Rollins, the defendant. The last 2 entries were especially pertinent to the investigation because it talked about how they were arguing towards the end leading up to the day of the crime.
Now, I want to go through each of those entries one at a time. Let's start with the first entry that you mentioned. What date is that?
That's dated January 16, 2015.
And what is the content of that journal?
It states that the defendant insisted on her husband keeping a knife in the dresser. It also insisted that she keeps a gun inside of her dresser drawer as well, knowing the fact that her husband didn't like
Objection, Your
guns.
Honor. Again, hearsay, they said this was not being used for the truth of the matter asserted. This is.
Well, that they indicated that. If it's, I'm overruling the objection. And, be read into evidence.
Yes, Your Honor. Could you repeat the last of that?
Yes, of course, certainly. So Miss Rollins insisted that she keeps a gun inside her dresser drawer, despite knowing that her husband didn't like guns in the room, in the house.
Now, what about the other journal entry? What date was that?
That was dated February 13, 2015, the day before the crime occurred.
And what was the content of that entry?
Here it states that the defendant accuses her husband of being abusive, but here it indicates, and I quote, the victim says, "I have never hit her and I don't intend to." Also, it talks about how the defendant had troubles with the victim and her husband was seeking a divorce and she didn't want that. It states that she would never let her husband divorce her, and her husband states here that he's fearful for her security.
Now, besides reviewing these journal entries, did you have an opportunity to talk to the defendant?
Yes.
Now, when did you talk to her?
Well, I had 3 different occasions to speak with her. The first time was on February 14, 2015.
What did she say then?
She said that she had a fight with her husband about his first wife. She said that she remembered pulling out a gun, and she said that she guessed she shot her husband.
When was that second time that you spoke with the defendant?
That was 2 days after, so it's the 16th of February.
And what did she say then?
She said she remembered a little bit more, and she talked about the troubles that she had with her husband regarding the women in his life.
What women are these?
It was particularly Jamie and his first wife, Candy Rollins.
I want to go through each of those women one at a time. Who is Jamie?
Miss Rollins she still owns a jewelry store called Cinnamon's Diamonds. Jamie is an employee there, so Jamie works for the defendant. The defendant had suspicions that her husband was having an affair and flirting with Jamie.
Now, what about Mrs. Rollins?
Now, the defendant told me that she had a problem with the fact that her husband never got over his first wife, Candy Rollins. He kept a photograph of her all around the house and also inside the bedroom that they shared, next to the bed. And she said that would set her off, and that was the reason why she was waving a gun in front of him, and that's how she shot her husband.
Now, what about the third time that you talked to the defendant? When was that?
That was 3 weeks later on March 5th, 2015.
Was a report done during that interview?
Yes,
Who initiated these 3 interviews?
Miss Rollins did. The defendant did.
And you had an opportunity to review that report after it was done?
Of course.
Showing counsel what has been pre-marked as State's Exhibit 8. Detective Stevens, do you recognize this document? I'm
I do.
showing you what's been pre-marked as State's Exhibit 8. How do you recognize it?
This is the exact transcript of the statement that the defendant had made when she came to the police station.
And
third time.
is that transcript in the same or substantially the same condition as when you previously reviewed it?
It is.
Your Honor, State moves State's Exhibit 8 into evidence.
No objection.
Exhibits received into evidence.
Permission to retrieve from the witness and publish for the members of the jury. Now, Detective Stevens, what did Ms. Rollins say this last time that you spoke to her?
If you can pull it a little bit. Yes. So she said that she hasn't been completely honest with me, like it says on the first paragraph. And also she said that she shot him when he was lunging at her. But right before that, she also contradicted herself and said that she shot him when he was reaching for a knife in the dresser.
How many shots were fired?
Just one.
Okay. And how did this statement compare to the physical evidence?
She said she shot her husband when he was reaching for a knife in the dresser. The evidence showed that the knife was on the dresser when it got there.
Oh, what about if he was lunging at her?
She said she had to shoot him when he was lunging towards her, at her. The evidence showed that he was shot in the back.
Now, how long after Ms. Rollins killed her husband did she make this last statement?
It was about a month after, I believe, around 3 weeks.
No further questions, Your Honor. Pass the witness. Could you erase that? Thank you. I'll retrieve that from you.
Cross-examination.
May I inquire?
Yes, sir.
Detective, you were investigated for receiving money you were not entitled to, correct?
Not receiving money. There had been some miscalculations in my travel expense in the past, if that's what you're referring to, counsel.
Yes, miscalculations on false travel claims that you received.
Yes, there was a miscalculation for the travel claim, so I immediately gave back the money that was miscalculated.
But you were investigated first before you giving that money back for receiving this money you were not entitled to. Isn't that correct?
Yes, because if there was a miscalculation, there was an investigation, yes.
And during this investigation against you, you'd agree with me, you expected a fair investigation, correct?
I don't understand. I apologize. I don't understand the question.
You'd agree with me that the investigation your agency had against you,
Yes.
you wanted them to conduct a fair investigation against you,
Yes,
correct?
of course, yes.
An investigation that didn't cut any corners, right?
Sure, yes, of course.
An investigation without any assumptions.
Yes.
And you were found to commit fraud.
No.
You were not found to commit fraud.
No, the exact term was that there was a falsified information, something that was not true, not fraud.
Okay, so you're telling members of the jury something that's not true and false submitted information is not fraud?
That's exactly what I'm saying. It was a miscalculation. I didn't intend to deceive them. It was a false record.
Okay, Detective. Well, let's move on to Cinnamon Rollins' house. When you arrived to her house, you were the only investigating officer there, right?
Yes.
The emergency personnel was there before you got there, right?
Yes.
They didn't wait for you to secure the scene before they went inside the house.
Yes.
They didn't wait for you to secure the bedroom before they went inside the bedroom, right?
Yes.
And they already evaluated Mr. Charlie Rollins' body, right?
I am not sure of that. That photograph that I've shown you in the direct examination is how I saw Mr. Rollins, and I don't believe they conducted the medical examiner's report at that time.
Well, the emergency personnel, they did all they can with the victim, right? With Charlie Rollins, didn't they?
I would assume so, yes.
Okay. Now, Detective, you didn't speak with any of these emergency personnel, did you?
No.
You didn't ask emergency personnel if they moved anything in that house before you arrived?
No.
You didn't ask emergency personnel if they had to flip over the body before you arrived?
No.
You didn't ask emergency personnel if they had to pick the knife
Objection,
up?
Your Honor. Asked and answered. My witness already said that he did not speak with emergency personnel.
The objection's overruled.
Detective, you didn't ask emergency personnel if they had to pick the knife up off the ground and put the cover on and put it on a dresser, did you?
No.
Now I want to talk about this knife. You collected it and you put it into evidence, right?
Yes.
And you thought this knife was significant, didn't you?
Yes.
You took the cover off the knife.
Yes.
You took a picture of it.
Yes.
You measured it, right?
I did, yes. It was part of the investigation to recover any pertinent evidence that I could find around the premises.
Okay, well, Your Honor, show in State Defense Exhibit 1. Permission to approach.
Yes, sir.
Detective, that's the knife you uncovered, correct?
Yes, it's the knife that is outside of his sheath. When I found it at the scene, it was actually covered in its housing, the sheath.
Right, and that's the knife you took a picture of, right?
It is, yes.
And that's the same knife you retrieved from Ms. Rollins' house.
Yes.
Your Honor, defense moves into evidence, Defense Exhibit 1 as Defense Exhibit 1.
No objection, Your Honor.
Received into evidence.
Permission to publish a copy of this to the jury.
Yes, sir.
Now, Detective, you sent this knife to the crime lab, right?
I did, yes.
And you had fingerprint analysis run on it.
Yes.
You had forensic evidence. You had strike that, Your Honor. And you thought this knife was significant, right?
Of course. Like I mentioned, there was a fingerprint testing done on it, and both the defendant and the victim's fingerprints were found on the knife.
Now, Detective, you have training in collecting forensic evidence, right?
Yes.
But you don't have training in testing scientific evidence, right?
No, that was all indicated by the report, by the forensic report.
And you don't have training in testing, scientific training in testing weapons either, right?
Right. Like I said, the testing were done by the scientists, and I reviewed the records.
So that's a yes.
Yes.
Now, Detective, I want to talk to you now about your conversations you had with Ms. Rollins. She told you on March 5th that her husband was abusive, didn't she?
Yes, that'll be the third statement about a month after. She did tell me that, yes.
Yes, so on March 5th, she told you that her husband was abusive.
My answer was yes.
She told you that her husband shook her.
She did tell me that, yes.
She told you that her husband threatened to kill her.
That's what she told me.
She told you that her husband, her kids were all plotting to ensure she never saw another wedding anniversary, didn't she?
That is what she told me on March 5th, a month afterwards, yes.
Now, Detective, she also told you it was life or death, didn't she?
I'm not sure if in those exact terms, but she did say that she had to shoot him on the third statement that she made to the police.
Right. She said she had no choice, right?
I believe she said she had to shoot him.
Right. Or she would be dead.
Yes.
Now, Detective, you didn't speak with any neighbors to see if they heard of any abuse, did you?
No.
Or any threats?
She only mentioned about the abuse about a month afterwards, so no. The first two statements never mentioned about any abuse, so it was unnecessary at the time. But afterwards, to answer your question, counsel, no.
Okay, so you felt like it was unnecessary to interview any employees to see if they heard of any abuse?
I didn't say unnecessary, but I did not investigate, no.
Detective, you didn't interview any employees to see if they heard of any threats either?
No.
You didn't interview the kids that said they threatened to kill her. You didn't check and see if those threats were true, did you?
I did not know.
And you would agree with me today, Detective, that it's important to have a thorough homicide investigation, right?
Right, of course.
And you'd also agree with me that it's important to have a fair homicide investigation,
Right.
a one with no assumptions.
Right.
I pass the witness.
Brief redirect, Your Honor. Detective Stevens, you were asked on cross-examination about what the defendant said about her husband in her March 5th statement. What had she previously said to you about her husband?
Well, on the second statement, that was about 2 days, that was exactly 2 days after the crime occurred, she said loving things about her husband. She said he was caring, gentle. She said only positive things about her husband.
Who lives at 161 Willow Glen?
Her husband and her, the defendant and the victim.
Why didn't you ask Charlie Rollins' kids about any abuse?
They weren't living in the house together, so even if I were to ask them, they wouldn't know about anything.
Why didn't you ask the employees?
They didn't, Miss Rollins didn't really have a good friendly relationship with them anyway, so I didn't find it necessary. They wouldn't know it.
No further questions, Your Honor. May the witness be excused.
Yes, ma'am. Prosecution, will call us next witness.
Yes, Your Honor. At this time, excuse me, the prosecution does call Dr. Alexis Crawford to the stand. Your Honor, while the doctor is approaching, may I set up the courtroom for use of an enlargement?
Yes.
Can you tender for me?
Good afternoon, Doctor.
Good afternoon.
May I inquire, Your Honor?
Yes.
Could you please introduce yourself to the members of the jury?
Sure, my name is Dr. Alexis Crawford.
Doctor, what kind of doctor are you? What do you do?
I'm a psychiatrist.
What is a psychiatrist?
Psychiatrist is someone who meets with people and talks to them and reviews records to determine if they suffer from any mental diseases, issues, or disorders.
Now, Doctor, where did you go to school?
I went to the University of Lone Star for my bachelor's degree, and I also attended the University of Lone Star for my medical degree as well.
Have you completed a residency?
Yes, I have.
What was that residency in?
I completed a residency at Lone Star Health and Sciences Center in psychiatry.
Doctor, are you board certified?
Yes, I am. I'm board certified by the American Board of Neurology and Psychiatry, as well as the American Psychiatric Association.
Now, can you tell the members of the jury, what is board certification?
Sure. Board certification is an accreditation that a doctor can receive in a specific field, and it's the highest you can receive in a certain subset of a field. Mine's in psychiatry.
Now, Doctor, I want to talk specifically about this case. How did you become involved?
I was asked by the state to determine whether Miss Rollins suffers from any mental diseases or disorders, specifically paranoid personality disorder.
How did you go about conducting that analysis?
Well, I met with Miss Rollins twice for 3 hours each for a total of 6 hours. I reviewed her statements to the police, and I spoke to some of her employees.
And having done that, Doctor, did you reach a diagnosis in this case?
Yes, I did.
Reaching that diagnosis, Doctor, did you have sufficient facts and data?
Yes,
Did you utilize reliable principles and methods that are common in the field of psychiatry?
absolutely.
Did you reliably apply those principles and methods to the facts of this case?
Yes,
Did you reach that conclusion, Doctor, to a reasonable degree of medical certainty?
yes.
Your Honor, at this time, pursuant to Federal Rules of Evidence 702, seeing the doctor's knowledge, skill, experience, training, and education, we move him as an expert in the field of forensic psychiatry.
Your Honor, two objections. One is to the basis under 702, but the second primarily is as to opposing counsel's request that the court recognize Dr. Crawford as an expert. The commentary from 2010 to the Federal Rules of Evidence explicitly speaks against identifying a particular witness as an expert to the jury, as it'll give the judicial seal of approval to one witness over another and should not be permitted.
Objections overruled.
Your Honor, I have an additional objection as to the foundation under 702, if it may be heard briefly.
Yeah, should have been made at the beginning.
Your Honor, it's in two parts. Simply that the expert hasn't laid sufficient foundation to establish his qualifications under 702. Simply a recitation of the four prongs that he did have sufficient facts and data, reliable principles and methods. It doesn't suffice to meet 702. He must show the jury that he does in fact have sufficient facts and data and reliable principles and methods. Just saying yes to those questions doesn't meet the rule.
And cross-examined during that time. Objections overruled.
Yes, Your Honor. Doctor, you mentioned earlier that you examined the defendant for paranoid personality disorder. Why did you do that?
Well, I was asked to determine whether the defendant suffers from any mental diseases or disorders that would affect her ability to think.
Now let's talk specifically about paranoid personality disorder. Can you tell us what that is?
Sure. Paranoid personality disorder is a disease where people think that others are out to get them or harm them, when in reality they have no reason for thinking that.
How do you diagnose someone with paranoid personality disorder?
Well, I looked to a book called the DSM, and in that book, in order to diagnose someone with paranoid personality disorder, there are 7 factors. If someone meets 4 of those factors, they can be diagnosed with the disease.
Let's break that down a little bit. You mentioned the DSM. What is that?
Sure. The DSM is the Diagnostic and Statistical Manual. It's a treatise or a book that people in my field read, and where it talks about what disorders are and how to diagnose people with them. I looked to that book, and I looked to see if Ms. Rollins met 4 or more of the 7 factors to meet the disease.
Well, when you mentioned factors, what are those?
Well, factors are certain signs or symptoms of a disease, and if someone exhibits signs or symptoms, then they can meet that factor and thus be categorized for the disease.
Showing defense counsel states 9 marked only for identification. Doctor, I'm handing you states 9 marked for identification. Can you tell the members, do you recognize that document?
Yes, I do.
And how so?
This is the diagnostic criteria as listed in the DSM for paranoid personality disorder.
Doctor, is that a fair and accurate copy of the DSM criteria that you relied upon?
Yes, it is.
State moves Exhibit 9 into evidence, Your Honor.
No objection.
Received into evidence.
Permission for the witness to step down and make use of an identical enlargement of states 9?
Objection to that?
No, Your Honor, so long as I can just reposition.
Be fine.
Doctor, if you could step down into the well, I'm going to go ahead and have you utilize this enlargement. Now, Doctor, I'm showing you an exact enlargement of states 9, marked only, or of states 9 that's been admitted. Now, can you explain to the members of the jury what it is we're looking at here?
Yes, we're looking at the diagnostic criteria for paranoid personality as listed in the DSM, the book that I looked to in order to determine whether Ms. Rollins suffers from the disease or not.
Now, earlier you mentioned that you reached a diagnosis. What was that diagnosis, Doctor?
I concluded that Ms. Rollins does not suffer from any mental diseases or disorders, including paranoid personality disorder.
Why did you reach that diagnosis?
Well, I reached that diagnosis for 3 reasons. First, for some of the factors, 2 specifically, I found that the defendant did not show any signs or symptoms, so I could rule those out. Then, for the other factors, though she may have showed some signs or symptoms, they either were justified, which was precluded by the factor, or, in my expert opinion, they didn't rise to the level pervasive enough in order to be diagnosed as a disease. And so I found she did not meet that criteria. Lastly, in my interviews with the defendant, I found that she was trying to be deceptive or manipulative, and so it made me distrustful.
Objection, improper opinion.
Proper opinion based upon...
As to the expert's conclusionary statements that Mrs. Rollins was acting deceptively or acting in a way to deceive him.
Overrule the objection.
You can continue, Doctor. You were talking about your third influence on your investigation.
Yes, the third reason was that in my interviews, based on some of her answers, she seemed to be acting deceptively or trying to manipulate her answers in order to get a more favorable diagnosis.
So let's go through each of those one at a time. Which factors did you say did not apply at all, Doctor?
Well, I found that factors 3 and 6 did not apply at all.
Now, doctor, I'm going to go ahead and hand you this marker, and I want to go through those factors. And if you find that a factor does not apply, if you could put a red X next to it.
Sure.
Let's start with factor 3. It talks about being reluctant to confide in others because of fear that information is going to be used against the person. What did you find regarding the defendant in factor 3?
Well, though I found the defendant was reluctant to confide first, I found that she did not meet this criteria because she opened up to me. She spoke to me about a number of issues, quite personal issues, including the shooting, her childhood, her family, and so I found that she wasn't reluctant to confide in others, and so I'll mark this with an X.
Similar question for factor 6, doctor. Why didn't that factor apply?
Well, I found that Ms. Rollins did not perceive attacks on her character that weren't apparent to other people. Based on my interviews with her and review of the record, I found no instances where she did this, and so I'll mark that with an X that she didn't meet this factor.
Now, I want to move on to the second part of your diagnosis that you mentioned. Which of these factors applied only in part?
Well, the rest of the factors applied only in part. 1, 2, 4, 5, and 7.
Now, you mentioned earlier they applied, but not to the extent required. What do you mean by that?
Well, for some of these factors, the rule requires that the suspicions be unjustified. So though she may have suspected others of harming her, the factor explicitly says that it must be without sufficient basis. And so if I found that she had sufficient basis for those suspicions, she couldn't meet the factor.
Well, let's go right to factor 1, the one you were mentioning. What was your conclusion regarding factor 1?
I found that she did not meet factor 1 because even though she suspected others of harming her, or she was suspicious of others, I found that she was justified in those beliefs. So I'll mark that with an X.
Now, specifically, doctor, factor 2 about a preoccupation about unjustified doubts of the loyalty or trustworthiness of people the defendant knows. What did you find regarding that factor?
I found that Ms. Rollins does not meet this factor. Though I was aware, and Ms. Rollins expressed that she was suspicious about the loyalty or trustworthiness of some of her employees, I found that she was justified, which the rule precludes. So because her suspicions were justified, I didn't find that she meets this factor. Specifically, she was concerned about maybe one of her employees was cheating on her or stealing from her. I found that she was either being a good, vigilant business owner, or that she actually was justified in thinking that there may be something going on. Her husband met her at that jewelry store after all. So I found that her suspicions were justified.
Now, doctor, is there any significance with you finding factor 2 to apply?
Yes.
What is that?
Well, just based on these 4 factors, I can conclude that Ms. Rollins does not suffer from paranoid personality disorder, even if she met the last 3.
Now, let's talk about those last 3. Did you look at factor 4?
Yes, I did.
What did you find?
Well, I found that even though Ms. Rollins did read hidden meanings into benign remarks, it didn't rise to the level pervasive enough in order to be categorized as a disease. And so I'll mark that with an X.
Now, doctor, same question for factor 5 about persistently bearing grudges. What did you find regarding that factor?
So I found that Ms. Rollins did not meet this factor. Though it did seem in our interviews that Ms. Rollins held a grudge against her father and her sister, I found that the grudge she held against her father was justified because he did not attend her wedding, didn't approve of their marriage, did not approve of her in many ways, and that the grudge she held against her sister was like a sibling rivalry. And so I found it wasn't enough to rise to the level under paranoid personality disorder criteria. So I'll mark that with an X.
And doctor, same question, but let's look at the last factor, factor 7. What did you find regarding that factor?
Well, I found that Ms. Rollins does not meet this factor. This is another one of the factors that requires for her suspicions to be unjustified. And though Ms. Rollins was suspicious regarding her husband's fidelity, whether or not he was cheating on her, I found that she was justified in being suspicious. So I'll mark that with an X.
Why did you find she was justified?
Well, I found that she was justified because Ms. Rollins expressed to me that Mr. Rollins would go out with women who he was friends with, who he'd known for a long time. These women she described as worldly, sophisticated, beautiful, and that he would go out with them without Ms. Rollins. And so I found that she was justified in being suspicious of her husband.
So, doctor, how many of these criteria apply to the defendant?
Not one.
Thank you, doctor. You can retake the stand. Permission to preserve the demonstrative for closing arguments, Your Honor?
Yes.
Doctor, I want to talk about the third thing that you mentioned in your diagnosis. You mentioned that the defendant was being manipulative. What do you mean by that?
Yes, well, she seemed to be being deceptive in her interviews with me. For instance, I would ask her something and she would maybe give one answer, and then I would ask her about something else and she would change her answer and refuse to believe that she gave that first prior answer.
Do you have an example of that behavior?
Yes, specifically when I asked her about her father, when I was speaking to her about her sister, and she spoke lovingly in regards to her father, said nice things about him. But then when I asked specifically about her father, she changed her answer and refused to believe that she just said those kind words about him.
How did this behavior affect your diagnosis of the defendant?
It made me distrustful of her, and so it confirmed that I did not think she met the criteria for paranoid personality disorder.
Thank you, doctor. Pass the witness.
Cross-examination, please.
May I inquire?
Yes, sir.
Dr. Crawford, you agree that more information is better than less information when evaluating someone for a mental health disorder, right?
Sure.
So in this investigation, you sought out as much information as you could get, right?
I did what I believe was a thorough analysis.
Okay, so that's a yes to my question? You sought out as much information as possible?
I sought out what I thought was relevant information.
Okay, so you get to decide what's relevant.
I just do the best investigation I can.
Well, Dr. Crawford, I'm trying to understand what that investigation consists of. You get to decide what's relevant, right?
I interviewed the defendant and tried to talk to her. I reviewed her statements. I spoke to her employees. I thought that this would be helpful in coming to a diagnosis.
Thank you, Dr. Crawford. My question was very simple. You understood my question.
Yes, I do.
You choose what information is relevant and what information is not relevant. Yes or no?
In my expert medical opinion, yes.
Okay. Let's talk about the information you chose. You evaluated Mrs. Rollins for paranoid personality disorder.
Correct.
You understand that there are 7 factors.
That's right.
Some of those factors relate to relationships, right?
Yes.
Relationships with family, with friends,
Yes.
with associates.
Sure.
So you sought out Mrs. Rollins' family, right? You talked to her sister.
No, I did not speak with her sister.
You sought out her father. You talked to him, right?
No, I didn't speak out. I didn't speak with her father. She said that she didn't really have much of a relationship with him, so I didn't think that that would be relevant.
Dr. Crawford, my question was about your investigation. You didn't speak to her father.
I did not.
You didn't speak to her neighbors.
No, I did not.
You didn't speak to any of the investigators in this case.
I did not. I read her statements to the police.
You didn't speak to the EMTs that arrived first to the house.
Nope.
But you felt comfortable coming to a conclusion, right?
Yes.
You agree that paranoid personality disorder is a real mental health disorder.
Yes.
It affects real people
Yes.
in real ways.
Yes.
It's severe.
Sure.
Causes paranoia,
Yes.
causes suspicion.
Yes.
The first word in paranoid personality disorder is paranoia, right?
And I'm sorry. Can you repeat the
The
question?
first word in the name of the disorder is paranoia, right?
Paranoid. Yes.
You agree that Mrs. Rollins suffers from paranoid characteristics, right?
Though she shows some symptoms of it, I didn't find that she met the disease.
That wasn't my question, Dr. Crawford. I'm asking about the opinion you gave. You agree she exhibits paranoid characteristics, yes or no?
Yes.
I want to talk to you about your experience in this case. This isn't your first time in trial.
No, it's not.
You've been in court before.
Yes.
You've testified in over 30 cases.
Yes, I've been received as an expert, yes.
That was my question. You testified in over 30 cases.
Yes.
Each and every time it's been for the state,
It just so happens that way, yes.
never once for the defense.
That's right.
And you're being paid for your time today, right?
No, I'm being reimbursed for my expenses.
Okay, well, tell the members of the jury how much you're being reimbursed.
As long as my expenses are reasonable, I'm just being reimbursed for my expenses.
I'm looking for a number, Dr. Crawford. Tell the members of the jury
Objection,
how much.
Your Honor. Relevance as to the exact number he's being reimbursed.
Rule.
Tell the members of the jury how much money you'll be paid after this trial.
I don't know.
I pass the witness, Your Honor.
Brief redirect, Your Honor.
Okay.
Doctor, why didn't you speak to Miss Rollins' father or her sister?
Miss Rollins told me that she didn't have much of a relationship with them, so I didn't think that it would be helpful in coming to a diagnosis.
Why not, Doctor?
Well, if they didn't speak with her and they didn't know much about her, then I didn't think that it would help me determine whether or not she suffers from a disease.
Thank you, Doctor. No further questions for this witness, Your Honor. May be excused.
Yes.
May I tender evidence to the bench?
Yes. Is defense prepared to call the first witness?
After a motion, Your Honor?
Go ahead.
Pursuant to Federal Rules of Criminal Procedure Rule 29, defense moves for a judgment of acquittal, as the state has failed to make a prima facie showing that would allow a reasonable jury to convict Mrs. Rollins of the crime charged. Specifically, even in the light most favorable to the non-moving party, the state has failed to present sufficient evidence to support knowledge or intent, as is required under the charge of murder, and to disprove self-defense, as the state, by entering Mrs. Rollins' third statement, has now put self-defense in play.
Brief response.
Yes, Your Honor. At this point in the proceedings, the evidence is viewed in the light most favorable to the non-moving party, that being the state. We have put forth the journal entries of Charlie Rollins with circumstantial evidence suggesting that Ms. Rollins did, in fact, read those journals, providing the members of the jury with a motive. Additionally, Your Honor, we have put forth evidence that Ms. Rollins knew exactly what she was doing. We put forth the third statement in which she acknowledged that. And at this point in the proceedings, we do not carry a burden as to self-defense. So we ask that this question go to the jury.
The motion for acquittal is overruled. You can call your first witness.
Your Honor, at this point, now that the state has rested before the defense begins their case in chief, would Your Honor be amenable to a brief 5-minute recess for the comfort of the members of the jury?
5 minutes. That's fine. Defense can call its first witness.
Defense calls Dr. Casey Prescott to the stand. May I proceed?
Yes, sir.
Please introduce yourself to the jury.
Good afternoon. My name is Dr. Casey Prescott.
Dr. Prescott, why are you here today?
I'm here because I evaluated Ms. Cinnamon Rollins.
Okay, Dr. Prescott, before we go into your evaluations of Ms. Rollins, I want to talk a bit about your background, your medical background and education. What do you do for a living?
I'm a licensed psychiatrist.
What psychiatry?
Well, psychiatry is the study of mental disorders and the treatment of people who suffer from those disorders.
What does one have to do to become a psychiatrist?
One would have to go to medical school, specialize in psychiatry, and then get a residency in psychiatry.
Can you tell us where did you go to school?
Sure. I went to my undergrad at Baylor University, where I graduated summa cum laude and majored in psychology. Then I went to Oklahoma University, medical school, graduated cum laude. And then I completed a residency at the University of Lone Star's Health and Science Center.
Can you tell members of the jury a little bit about your certifications and licenses as a psychiatrist?
Sure. I am licensed by the state of Lone Star to practice psychiatry. I also am board certified by both the American Board of Psychology and Neurology and the American Psychiatric Association.
Have you testified in any criminal trials before?
Yes, I have. I've testified in 35 criminal trials.
Have you testified for both the prosecution and the defense?
Yes, I've testified for both, mostly for the defense, but I have testified for both.
Now, doctor, are you getting paid for your time here today?
Yes, I'm getting paid my standard rate.
And is there any way this will affect your testimony?
No.
Now, I want to talk about your evaluations with Cinnamon Rollins. Why were you evaluating her?
I was evaluating to see if she suffered from any mental disorders.
And what'd you come up with, doctor?
Well, I concluded that she definitely was suffering from a mental disorder, a specific one, called paranoid personality disorder, or PPD.
What is paranoid personality disorder?
Paranoid personality disorder is a pervasive distrust in the person who suffers from it. They think that everyone around them has a malicious intent.
And how do you diagnose one of this PPD, or paranoid personality disorder?
Well, a psychiatrist would consult the Diagnostic and Statistical Manual. It's basically a psychiatrist's handbook, and we use it to diagnose all sorts of mental disorders. In this specific case, I would look toward the paranoid personality disorder criteria. There are 7 of them. And someone would have to suffer from 4 of those criteria, and if they do, they suffer from paranoid personality disorder.
Doctor, I'm showing you State's Exhibit 9. Do you recognize this?
Yes, I do.
How do you recognize this?
Well, this is the same diagnostic criteria that I used to diagnose Miss Cinnamon Rollins. Up there on the top is the description of the disorder, and the next under that are the 7 criteria, only 4 of which someone would need before being diagnosed with paranoid personality disorder.
Are these the same general principles and methods that you use when diagnosing Ms. Rollins?
Yes, they are.
And did you diagnose her to a reasonable degree of medical certainty?
Yes, I did.
Now let's talk about this. Who all did you interview when your diagnosis with Cinnamon Rollins?
Well, I interviewed Miss Cinnamon Rollins for a total of 9 hours. I also interviewed her jewelry store employees, her sister, a niece, as well as the investigating detective, Detective Taylor Stevens.
Can you tell members of the jury what all you relied on when you diagnosed Cinnamon Rollins?
Sure. I relied on really 4 key areas. First was my initial impressions of her when she came in. Second was her description of her childhood. Third was her conversation about her jewelry store employees. And then finally, her description of the events of February 14th, 2015.
Dr. Prescott, would a visual aid help you in your testimony today?
Yes, it would.
Your Honor, permission for the doctor to step down from the stand
Yes, sir.
and make use of this visual aid.
Yes, sir.
Dr. Prescott, can you tell the jury what we're looking at here?
Yes. We have here 7 boxes that I've drawn. Each of these 7 boxes represents one of the 7 criteria that correspond to paranoid personality disorder. When I say a fact that was significant for my diagnosis, I'll make a check mark on one of these boxes. That means that Cinnamon Rollins suffered from that criteria.
Okay, doctor, let's start with the first thing you said you relied on. You said you relied on your initial interviews, your initial impressions. Can you tell the jury why that was significant in your diagnosis?
Yes, when she came in, she was reluctant to speak with me. In fact, even innocuous questions, she would ask why before answering, why I was asking. And she also believed that I was going to give information over to her stepchildren and deceive her in that way. So I immediately saw that she exhibited, and those facts were significant, that she suffered from the first criteria, suspecting without sufficient basis that I was going to exploit her. The second criteria, preoccupied with the loyalty of friends or associates, her stepchildren. And then the third criteria, she was reluctant to confide in me because I would use that information for malicious intent.
And you said the second thing you relied on was her childhood. What was significant in that conversation, and how did that help with your diagnosis?
Yeah, she spoke about her sister and niece, only in relative terms, as a niece being smarter, prettier, and the apple of her father's eye. And I saw that from childhood up until now, Ms. Cinnamon Rollins bore a grudge against her sister and niece.
Did you speak with Ms. Rollins about her parents at all?
Yes, I tried to elicit information about her mother, but Cinnamon Rollins was very evasive about that. She didn't want to speak about it, but she did open up and say she found her mother dead.
Objection, Your Honor. May we approach?
You can make your objection from there.
Yes, Your Honor. I believe the witness is about to go into information concerning the defendant finding her mother dead in a swimming pool when she was young. This evidence is a violation of Federal Rules of Evidence 403. It serves no medical purpose for the doctor, but simply serves to confuse the jury and manipulate the issues by causing sympathy for the defendant.
I overrule the objection.
Doctor, please continue on your conversation about Ms. Rollins finding her mother dead.
Yeah, so she found her mother dead in the family swimming pool and immediately changed the subject to being a cheerleader. It was obviously didn't want to talk about it.
And how was that significant in your diagnosis?
Well, that was significant because she was suspecting that I was going to take that information, right? She suspected that I was going to exploit her from that. And she especially came at me when I asked her, did you go to college? She came at me and said, accused me of being her father. Right? Such an innocuous question. She read a hidden meaning into that benign remark, that benign question, did you go to college? And then after that, she reacted angrily, which showed me that she also suffered from the 6th criteria, which was perceiving an attack on her reputation in college, and then reacting angrily.
Now, Doctor, you also said you spoke with her about her employees.
Yes.
How was that conversation significant in your diagnosis?
Well, she spoke about one employee in particular, a Jamie, and she said that Jamie was stealing from the cash register. But when I checked the books at the store and when I spoke to other employees, I learned that these were completely unjustified suspicions. And so that showed me that Cinnamon Rollins was definitely suffered from the 2nd criteria again, preoccupied with loyalty of associates.
What else did Ms. Rollins say about Jamie?
Well, she felt that Jamie was having an affair with Cinnamon's husband, Charlie Rollins. In fact, it was a recurrent suspicion, but I learned that this was also without justification. So I saw that Cinnamon Rollins was also suffering from the 7th criteria, recurrent suspicions of infidelity of her spouse.
Now, Doctor, you said you spoke with Cinnamon Rollins about February 14, 2015.
Yes.
Now, what was significant in that conversation?
Well, it was significant that she started out by speaking about the events of the night before. There was an argument. And in that argument, Charlie, Cinnamon's husband, said that he wanted a divorce specifically because of her recurrent suspicions of infidelity. This was something that pervaded their marriage. And he said that it was because of this criteria and because she suffered from it that he wanted a divorce.
Dr. Prescott, have you had an opportunity to review the statement she made to the police?
Yes.
Was there anything significant in those statements that helped in your diagnosis as well?
Yes. The 3rd time she spoke to police, she mentioned that she wanted to tell the truth because previously she was afraid that the information she shared would be used again to give to her stepchildren, the same thing she told me. So I saw that she was definitely suffering, again, from these statements from the 1st criteria, suspecting without basis that others were going to deceive her or exploit her. The 2nd criteria, unjustified doubts about loyalty, and the 3rd criteria, which was reluctance to share information because of malicious intent.
Dr. Prescott, after you took everything in evaluation, what was your opinion about Cinnamon Rollins?
Well, when I reviewed the criteria and my facts, I realized that she was definitely suffering from paranoid personality disorder. Someone only needs 4 of these criteria to be diagnosed, and she had facts in all 7 of them, and most of them more than one.
How did paranoid personality disorder affect her behavior on February 14, 2015?
Objection, Your Honor. Pursuant to Federal Rules of Evidence 704B, an opinion on the mental state of an individual that goes towards the crime charged is specifically prohibited, and that's exactly what this question is calling for.
Objections overruled.
Dr. Prescott, I'll ask you again. Because, you said she had paranoid personality disorder. How did this affect Ms. Rollins' behavior on February 14, 2015?
Because she had paranoid and has paranoid personality disorder, she's more likely to perceive that an innocent action would be malicious and that she would react quickly and angrily.
I'll pass the witness, Your Honor. Permission to preserve the board?
Yes, sir.
Cross-examination, Your Honor.
Yes, sir.
Doctor, in 2009, you published an article entitled Diagnosing Personality Disorders for Trial, right?
Yes, that was my first article.
You listed that article on your resume that you submitted to court for this trial.
Yes, I did.
You were investigated for plagiarizing that article.
Objection, Your Honor. Relevancy?
Overrule.
Doctor, you were investigated for plagiarism in that article.
I was investigated for not attributing another professor.
That's plagiarism, right, Doctor?
I would not say that, no. It was a misattribution.
You wouldn't say that taking someone else's work and calling it your own is plagiarism. You'd agree with that?
Well, no, and the reason why is because there's an intent with plagiarism. I just did not attribute this professor. It was my first article.
All right, we'll move on, Doctor. You mentioned on direct examination that you looked into whether or not employees were stealing from Cinnamon Rollins' store, right?
Yes, because of her suspicion that they were.
You said, and I quote, "I checked the books," right?
The records.
You specifically looked at the records of the money in her store, right?
From the jewelry store employees, they tell me that she was not suffering. They told me that she had no justification behind their suspicions about Jamie stealing from the store.
So you asked the jewelry store employees about the information in the books, right?
I asked the jewelry store employees.
You didn't look at it yourself.
No.
Now, doctor, I want to talk a little bit about paranoid personality disorder. You would agree with me that nowhere in the DSM does it say that PPD, or paranoid personality disorder, causes hallucinations.
No, I wouldn't say that, but it does affect the person who suffers from it. It affects their perception because, for example, they would read hidden meanings that are benign. So it does affect their perception.
Thank you, doctor. My question was, nowhere in the DSM does it say that this disease causes hallucinations, right?
No, but it's important to note it does affect perception.
So that's a no to my question.
Like I said, no, but it does affect perception.
Now, you talked a little bit on direct examination about how Cinnamon Rollins was suspicious that her husband was cheating on her, right?
Yes, there were recurrent suspicions, and when I asked her for justification, she couldn't provide me any.
Now, there was a specific suspicion about an individual named Jamie, right?
Yes.
Now, you would agree with me that Jamie works with Cinnamon at her diamond store.
Yes.
Cinnamon Rollins wanted to fire Jamie, didn't she?
Yeah, she told me that she did.
And she actually told her husband that she wanted to fire Jamie, right?
That's what Miss Cinnamon Rollins told me.
And her husband convinced her not to fire Jamie, didn't he?
Yes, that's what Miss Cinnamon Rollins told me.
Miss Rollins suspected that the two of them were having an affair.
Yes, that's what she told me.
Now, doctor, you reviewed the police reports, the police statements that the defendant gave, right?
Yes, I did.
The ones on the 14th, the 16th, and on March 5th?
Yes, I did.
Now, those first two statements, on February 14th and February 16th, you'd agree with me that nowhere in those statements does the defendant mention a knife, right?
No, but that's consistent with her paranoid personality disorder.
So my question, to answer my question, she doesn't mention a knife, right?
No, like I said, she didn't, but that is consistent with her disorder.
Now, in that third statement, the defendant says that this shooting was self-defense, right?
Yes.
She says her husband was lunging at her with a knife.
Yes, she said that her husband was lunging at her with a knife.
She also said that her husband was reaching for a knife.
In that statement.
Now, doctor, you've been in court today, right?
Yes.
You've heard the testimony that was given by Detective Taylor Stevens?
Yes, I did.
You would agree with me that Charlie Rollins was shot in the back.
Yes.
That's the witness, Your Honor.
No redirect, Your Honor.
Thank you, sir. You can step down. Call your next witness, defense counsel.
Defense calls Mrs. Cinnamon Rollins to the stand. And, Your Honor, at this time I'd ask if the courtroom technician could just make use of the doc cam system.
Yes. I'm sorry. You need for me to do something?
Whenever you're ready, Judge. I just was waiting for you to...
Oh, no. Don't wait on me. You go right ahead.
Thank you, Your Honor. Please introduce yourself to our jury.
My name is Cinnamon Rollins.
Where do you live, Mrs. Rollins?
I live right here in San Antonio, born and raised.
Do you work?
I do.
What do you do for a living?
I own my own jewelry store.
Do you have any family here?
No, my father and my sister moved away. It was just me and Charlie.
Who is Charlie?
Charlie was my husband.
Tell the jury how you and Charlie first met.
We first met when he came into my jewelry store. He was buying a ring for his first wife. We instantly connected, but he was married. I didn't see him again for a couple of years when he came back into the store.
And what happened when he came back?
I unfortunately learned that his first wife passed away. We started talking, and that connection was there again. He asked me out on a date.
You mentioned that the two of you were married. When did you get married?
We got married on Valentine's Day of 2010.
What were the early years of your marriage with Charlie like?
They were good. They were. We loved each other very deeply, but then they got bad.
How did they get bad?
Charlie had a temper. He would flare up sometimes. He would yell at me, get angry with me, threaten me.
Did he ever physically abuse you?
Yes.
How?
One day, I thought that there was someone outside of our house, and I told Charlie. I said I thought someone was watching us. When I told him, he grabbed me by my shoulders, started shaking me, and he yelled at me to get a grip.
You mentioned that he would threaten you. How did he threaten you?
He threatened me with his words, his actions. He threatened to kill me.
Mrs. Rollins, did these instances of abuse and these threats, were they uncommon in your marriage?
At the beginning, they were. Then Charlie just got worse and worse.
Did the threats and the abuse continue until February 14th of this year?
Yes,
I want to talk to you about that day and the day before, the 13th. Do you remember that day?
yes, I do.
What were you doing on the evening of the 13th?
That was the night before our 5th wedding anniversary. Charlie had one of his flare-ups. Got into an argument. He yelled and he screamed, and it got to the point where I was worried about my own safety, so I ended up leaving the house that night.
Where did you go?
Stayed at a hotel.
Did you return to the house?
Yes.
Why?
Sometimes time had passed, Charlie would cool off a bit. I thought that maybe over the night Charlie would have calmed down and we would have been able to talk.
When you got back to the house, was Mr. Rollins calm? Was he cool?
No.
What happened?
I got to the house and I went to find Charlie to speak with him. I walked up the stairs. When I got there, I found him in our bedroom. I saw the knife on the bedside table, and Charlie started yelling and screaming at me again.
Do you remember what he said specifically?
Yes.
What did he say?
He said he was going to fix things forever.
What did he do?
When he went for the knife,
Mrs. Rollins, would you recognize a photograph of the knife if I showed it to you?
yes,
I understand this is going to be difficult, but on that screen there's going to flash a picture of the knife. I want you to tell me if you recognize it.
yes,
How do you recognize it?
that's Charlie's Rambo knife.
Where was this knife kept?
Usually kept in his bedside table inside a drawer.
And where was this knife on February 14th of this year?
On top of the drawer, on top of the table.
You mentioned that Mr. Rollins went for this knife. What did you do?
I went for the knife. I had my gun, and when he came at me, I shot him.
Do you remember what happened after that?
Yes, but in pieces.
What do you remember?
I remember calling 911. Then the EMS came. Eventually, an officer came.
Did you have the opportunity to speak with the officer?
Yes,
How many times?
3 times.
Do you remember those 3 statements?
Yes,
The first statement, when did you give that?
that was a couple hours after the attack.
Why did you tell the police what you told them in the first statement?
Still in shock so soon after what had happened. I told them everything that I could remember.
The second statement, when did you give that statement?
I believe that was around 2 days after the attack.
And why did you tell police what you told them that day?
I went there and I wanted to tell them everything. I wanted to tell them about the abuse and what had happened, but I didn't want to ruin Charlie's memory for his children. 3 kids who he loved, and I didn't want them to remember their father as an abuser.
The third statement, when did you give that statement?
A couple of weeks after the attack.
And to be clear, for each of these statements, were you asked to come in?
No,
Why did you give the statements?
I went in to talk to the police myself. I wanted to talk to them.
So for that third statement, what did you tell the police?
I told them the truth. I told them what he had done for years. He had abused me, yelled at me, threatened me. I finally realized that it was more important to tell the truth than just protecting Charlie's memory. I wanted them to know that it was a life or death situation. I had survived.
Thank you, Mrs. Rollins. Your Honor, I pass the witness.
Cross-examination, counsel?
Yes, Your Honor. Good afternoon, Ms. Rollins.
Good afternoon.
There were things about your husband that you didn't like, isn't that correct?
Yes,
For instance, you didn't like the fact that your husband flirted with your employees.
made me uncomfortable.
He flirted with one employee in particular, isn't that correct?
Yes, I thought that he did.
That employee was Jamie?
Yes,
And even after you suspected your husband and suspected Jamie of cheating with each other, you stayed with them.
I loved Charlie.
And even after you suspected Jamie of stealing from you, you kept her as your employee
Yes,
because your husband asked you to. Now, you did enter into an affair with a married man in
Objection,
response.
relevance, more prejudicial than probative. May I be heard?
Yes, sir.
Your Honor, this evidence is irrelevant as it's bad character evidence. It goes to disparage Mrs. Rollins, and it will only act to inflame the passions of the jury. It has no relevance as to any of the elements at issue in this case.
Counsel?
Your Honor, this goes to the motive as to why Miss Rollins would want to have her husband dead and her general emotions at the time of her husband's death.
I'm going to overrule the objection.
Now, when you thought that Jamie and your husband were having an affair, you had your own affair, isn't that correct?
yes, I felt unloved by my husband a lot, and I regret the affair.
You had that affair with a married man.
Yes,
Now, you also didn't like the fact that your husband spent time with women closer to his age, isn't that correct?
I was uncomfortable with some of the relationships that he had with some of his female friends. I was.
You described those women as beautiful, worldly, sophisticated,
Yes,
educated, and you couldn't stand that.
I couldn't stand his relationship with them. It made me uncomfortable.
And his relationship with them was that he went out to spend time with these women without you. Now, you also didn't like the fact that your husband kept pictures of his first wife in your house together, isn't that correct?
Another thing that made me uncomfortable, I didn't think it was fair.
He even kept a picture of his first wife in the bedroom that you shared together. And that upset you. Now, you read your husband's journal, isn't that correct?
No,
Would it surprise you that your fingerprints were found inside of that journal?
no, I probably moved it at some point.
Would it surprise you that your fingerprints were found on the page where he said he had wished he never
Objection.
married you?
Relevance?
Overrule.
Would it surprise you that your fingerprints were found on the page where he said he wished he had never married you?
Yes, I don't know what page you're talking about.
Now I want to take you through the statements that you made to Detective Stevens. You made 3 statements, isn't that correct?
Yes, I went in to speak to the police.
Now, I want to take you to that last statement that you made. Now, you told the detective that when your husband was reaching for a knife inside the dresser drawer, that's when you shot him.
No, I believe I told him that he was reaching for the knife on the drawer of the dresser.
In the dresser.
On the dresser.
Would it surprise you if that's not what you said?
Yes.
Now, you said that you shot him then, but you also said that you shot him when he was lunging at you. Isn't that correct?
I had to shoot my husband when I believed that he was coming at me.
Now, you would agree with me, Ms. Rollins, that you only fired one shot that day.
Yes, I didn't want to shoot Charlie.
So it couldn't have been when he was reaching for the knife and when he was lunging at you. It would have to be one or the other. You said you shot him in your statement when he was reaching for the knife, let's say in the dresser. But you also said that you shot him when he was lunging at you. If you only fired one shot, it couldn't be both. Isn't that correct?
I'm sorry. All I remember is that when he was coming at me, I had to shoot him.
Okay, so let's say that your husband was lunging at you. You've been sitting in the courtroom today, Ms. Rollins. You're aware that your husband was shot in the back? Now, this last statement that you made on March 5th, that was made 3 weeks, almost a month after you shot your husband. Isn't that correct?
Yes, I wasn't ready to tell the police about Charlie's abuse.
So you had 3 weeks to think about what you were going to say to Detective Stevens.
I had 3 weeks to gather the courage to tell the police that my husband was an abusive man.
No further questions, Your Honor. Pass the witness.
Brief redirect.
Yes, sir.
Mrs. Rollins, for clarity's sake, tell the jury where Mr. Rollins kept his knife.
He kept it in his dresser drawer.
And in your third statement to the police, where did you tell them Mr. Rollins usually kept his knife?
Drawer.
And did you tell the police specifically that it was in the dresser drawer that day? Nothing further, Your Honor. I ask that Ms. Rollins be excused.
You may.
Defense has no further witnesses, Your Honor, and we rest, subject to a motion.
You may make your motion.
Your Honor, under Federal Rules of Criminal Procedure 29, defense moves for a judgment of acquittal. Specifically, Your Honor, the state has to prove a prima facie case today, and they have not done so specifically on intent. They have not proven today that Cinnamon Rollins intended to shoot her husband. Also, Your Honor, on the second grounds, they have not proven self-defense here today. They have not proven that Cinnamon Rollins did not try to defend herself on February 14, 2015. Thus, the defense moved for a judgment of acquittal.
Response?
Your Honor, turning to counsel's first point, we've admitted to the defendant's third statement to the police in which she acknowledges intentionally shooting her husband. While I'm aware it's in self-defense in her words, she acknowledges pulling the trigger. As to self-defense, Your Honor, we've heard medical testimony that the defendant was of sound mind on the morning of February 14th, and thus this act could not have been in self-defense as she claims. And so we have presented enough evidence for this question to go to the jury.
The motion for acquittal is overruled. And we will now proceed to closing arguments on behalf of the prosecution.
Yes, Your Honor. May I have a moment to assemble the courtroom?
Yes, sir.
May I retrieve evidence, Your Honor?
Yes, sir.
proceed, Your Honor?
Yes, sir.
May it please the court, counsel, members of the jury. She shot him in the back, and today she's out of stories. Members of the jury, there were a lot of things that the defendant didn't like about her husband. She didn't like that he would keep pictures of his first wife in their home. They didn't like the fact that he would go out with other women. And she didn't like the fact that he would flirt with the employees at her jewelry store. And so what happened, members of the jury, is that the defendant read the journal entries of Charlie Rawlins. And she learned that he wanted a divorce, and he told her that their marriage was over. And so on February 14th, 2015, the defendant walked into the home that she and her husband bought together when they got married. She walked up to her bedroom. She pulled out her firearm, a .38 caliber revolver, and she fired one shot. Because one shot, members of the jury, was all it took with the victim's back turned. And after she did that, she told story after story to the police. And as each one fell apart under the evidence, the defendant came up with a new one. But members of the jury, you know today that the defendant is out of stories. Now, as the state, Ms. Thomas and I, we do bear the burden of proof. We have to prove to you that the defendant, intentionally or knowingly, caused the death of her husband. And we also have to prove to you that that wasn't self-defense. So I want to turn to those first things first. I want to talk about whether or not she intentionally killed her husband. Now, it's not in dispute today, members of the jury, that Cinnamon Rawlins killed her husband. She came on the stand today and she admitted that. And we also know that she did it intentionally and aware of what was occurring. Not only did Ms. Rawlins tell you that she fired that shot, but Dr. Alexis Crawford came before you today and told you that Cinnamon Rawlins had a clear state of mind at the time of the incident, that there were no mental diseases or disorders clouding her judgment. She intentionally shot her husband, and she knew exactly what she was doing. So, members of the jury, we turn to self-defense. We turn to the desperate argument that the defense has made, their attempt to flip through the diagnostic and statistical manual and find the perfect disease that will allow Ms. Rawlins to get away with these statements that she made, will allow Ms. Rawlins to invent information to get away with murder. But there are two problems with that, members of the jury. First, Ms. Rawlins doesn't have paranoid personality disorder. And second, she proved to you on the stand today that she read those journals and she knew exactly what she was doing. Now, turning first to paranoid personality disorder, members of the jury, you saw Dr. Alexis Crawford take the stand. Dr. Crawford used this diagram, and Dr. Crawford walked through each of the factors in this diagram, and he told you that the defendant does not meet any of the required criteria. He told you that she doesn't have paranoid personality disorder. Well, and members of the jury, he also hasn't plagiarized any research work in the past. The doctor gave you credible, expert testimony that Cinnamon Rawlins was of sound mind. But members of the jury, you don't have to take my word for it or the doctor's word for it. Because think about what you heard from Dr. Casey Prescott when he told you that paranoid personality disorder, well, it's not a disease that causes hallucinations. It's not a disease that causes you to see something when it didn't happen. But members of the jury, the defendant, well, she can't have it both ways. Because you will have her third statement to the police when you go back to deliberate. And in that third statement, members of the jury, she says within one sentence, I shot him as he reached for a knife. but I shot him as he was lunging at me with a knife. It's an obvious contradiction, even if the defendant didn't want to admit it. And members of the jury, what you know is that paranoid personality disorder, it can't be responsible for that kind of a contradiction. An individual with paranoid personality disorder wouldn't imagine something happening when it just didn't happen. Because members of the jury, there's a second thing you have to remember. There was something very curious that occurred earlier when the defendant mentioned the email, the journals that her husband wrote. The defendant told you that she didn't read those journals. But earlier in her testimony, she told you that her husband had a Rambo knife. Well, that's an interesting term. Rambo knife. Where did that come from? Well, I can tell you where it came from. What you're looking at here is the 4th page of the journal entries that you're going to have to review. 1/16/2015, a month before the murder. He insisted that I keep my Rambo knife in my drawer. Well, there it is, members of the jury. Where did that term come from? Well, the defendant read it in these journals that her fingerprints were all over. But that wasn't the only thing she read. She read in this journal that her husband wanted a divorce. And she couldn't allow that to happen. Remember what she told you today. What was reflected in her second statement to the police. That she just wasn't going to allow that to happen. Or her first statement. That she needed to scare her husband back into loving her. So members of the jury, while I understand that this is a challenging proposition, to have a woman come before you today who appeared and came before you looking as an abused woman. But members of the jury, these are new claims. Miss Rollins is not abused. Charlie Rollins said so in those journals, that he never intended for anyone to read, that he would never hit his wife. And in fact, up until March 5th, that's what the defendant said too. Because members of the jury, the defendant knew exactly what she was doing. She walked into the house that day knowing that she couldn't let her husband leave. So she waited for the perfect moment and she shot him in the back. She shot him in the back, not in self-defense, but because she wanted him gone. And so members of the jury, I ask you to find the only verdict that justice allows today. I ask you to find the defendant guilty. Because she shot him in the back. And today, she's out of stories. Thank you.
We'll recognize the defense to make its closing argument.
Can I set up the courtroom and also get a time check?
Yes, sir.
Thank you, Judge. Thank you, ma'am. Please, the court.
Yes, sir.
It was life or death. On February 14th of this year, Mrs. Cinnamon Rollins had a split second to decide. She was forced to decide between life or death. She chose life. But in order to do so, she had to cause the death of her husband. That's not murder. That's self-defense. Today, the evidence didn't show that Mrs. Rollins was jealous or angry, as the state wants you to believe. It was fear. Today, the evidence showed that Mrs. Rollins was afraid. She was afraid of her husband. She was afraid of his knife. She was afraid to die. Because of that, she defended herself. That's not murder. That's self-defense. This case today presents one question for you to answer, members of the jury, one question that the law requires you answer. What was going on in the mind of Miss Cinnamon Rawlins at the time Mr. Rawlins died? So how do we know? How do we know the answer to this question? We look to the evidence. We look to facts. We look to some of the expert testimony we heard and some of the testimony of other witnesses. And in doing so, you, members of the jury, you'll find the same three key facts that Mr. Mike spoke of at the beginning of this trial. That Mrs. Rawlins suffers from a mental health disorder, that because of that disorder and because of the abuse that she suffered for years, she was afraid. And finally, because of that fear, she acted to defend herself. To her mental health disorder, we heard today from Dr. Casey Prescott, a board-certified psychiatrist, an expert in his field, and Dr. Prescott took the stand today, and he explained paranoid personality disorder, PPD. He told you what it is. He told you how it affects people. It causes severe, recurrent suspicions, fear. And he told you how Mrs. Rawlins is afflicted by this disorder, how she suffers from it every day of her life. Now, Dr. Prescott didn't just tell you that. He didn't just say he thought that was the case. He brought you something special. He brought you evidence. He brought you facts. Dr. Prescott used this chart to show you each and every one of the facts that he found in his evaluation of Mrs. Rawlins and how they supported the 7 factors of PPD, those 7 criteria. And in doing so, over a dozen facts supported each and every one of the 7 criteria. Dr. Prescott told you that you only need 1 check mark in 4 different boxes, 4 check marks total, and that would be enough. But he brought you more, because Mrs. Rawlins suffers from this disorder. Now, you might be confused, because certainly the state brought you Alex Crawford, and he told you that Mrs. Rawlins doesn't suffer from any of the 7 criteria. Why? Why the difference? Well, we could look to Dr. Crawford's history of testifying. For the defense, always for the defense, never, or always for the state, always for the state, never for the defense. In over 30 trials. We can look to the financial gain. A blank check with Dr. Crawford's name on it. We don't know how much he'll be paid. He couldn't tell us. Couldn't even venture a guess. We could look to his methodology. We could look to his assumptions. You heard a lot of assumptions in this case today, and I want to stop here and talk about how important they are, because it's the state's job today to prove to you beyond and to the exclusion of every reasonable doubt what they're claiming happened. Not beyond or to the point of every assumption, not probably we assume she did it. They have a heavy burden. And so when Dr. Crawford tells you he assumed that people wouldn't have necessary information, he gets to choose who has relevant information. That should concern you. Because Dr. Crawford is just racking up another testimony for the state. So what does that mean? What does paranoid personality disorder mean for your verdict in this case? This is jury instruction number 4. Just a few moments, the judge is going to instruct you on the law, and when he does, he'll read from the jury instructions. And I want you to pay close attention to number 4. Because in this instruction, it talks about something particularly important with regards to PPD. That it's your job to look to the condition of the mind of Mrs. Rawlins. What's going on up here? So it doesn't matter what's going on in the mind of the state counsel or myself. It matters what's going on in Mrs. Rawlins' mind. And on February 14th. And that's how you evaluate paranoid personality disorder. Because it affected her mind that day. What she perceived. What she thought was happening. And because we know Mrs. Rawlins suffers from this disorder, we look to the fear that she felt. That disorder, coupled with the abuse that she suffered in her marriage, told her that when Mr. Rollins went for that knife, she was going to die. Let me explain. Mrs. Rollins took the stand today. She didn't have to, but she did, under oath. She tried her best to testify. She gathered the strength to testify. And when she did, she told you something without even knowing it. She told you about a pattern that Mr. Rollins regularly, in the past, would yell, he would scream, he would argue, he would threaten her, and he would threaten to kill her. February 14th, he yelled, he screamed, he argued, he threatened her, he threatened to kill her. He said, "I will fix things forever." Forever. But he did something different that day. That day, he had armed himself. He had set a large knife on the bedside table, and when he went for that knife, Mrs. Rollins had to do something. She was forced to make a decision, whether she would live or she would die. She thought back to all of the times that he grabbed her and shook her, threatened to kill her, abused her, yelled at her. She told you today that she told police about that abuse. Certainly, State's counsel makes a big showing of why Mrs. Rollins wouldn't have told everyone about this abuse in the days, the weeks, the months leading up to this event. Members of the jury, you can use your common sense and experience with people in understanding why a woman who's abused wouldn't want to tell other people that she's being abused. A woman who's being threatened with her life wouldn't go to her husband's family, their neighbors, her employees, and tell them about this abuse, because she knew what her husband was capable of. When she finally was able to tell the police, the people she thought she was safe with, they turned their backs on her. They refused to investigate it. Detective Stevens told you he refused to investigate it because it wasn't significant. It wasn't what he thought had happened. Based on that fear, Mrs. Rollins defended herself, and that's that third fact. She told you how she had to shoot her husband to save her own life. One time. Not 5 times, not 6 times, not emptying the cylinder and then reloading and shooting him again. It's not a crime of passion or anger. One time to defend herself. And so when the state tells you that we don't know, as they did in their opening statement, we don't know how he got shot in the back, exactly. That's their job. And Mrs. Rollins doesn't know either because it was a split-second decision. Maybe Mr. Rollins was coming down low, and she shot his back from above. Maybe Mr. Rollins came at her with that knife and decided, I better turn around and get out of here. We don't know, and because we don't know, you have reasonable doubt. Now, we would know if Detective Stevens had done a thorough investigation, the kind of investigation that he expected when he committed fraud. Now, he wouldn't tell us today that he committed fraud. He wouldn't admit that. But, false travel claims, he called it false documentation. False documentation. So when you look at all the documentary evidence that Detective Stevens presented to you today, I want you to think about that false documentation he filed in the past for his own financial benefit. But nonetheless, Detective Stevens conducted what he wanted to refer to as a thorough investigation. Now, he didn't investigate her claims of self-defense. He didn't investigate by talking to neighbors, to friends, to family members, to employees. He didn't even speak to the EMTs, the people that work for the state. Could have picked up the phone and called them. Said, hey, by the way, did you move a body? Did you move a knife? I just want to double check. No, he wanted to assume that they hadn't. So don't be fooled. When you see a knife on a dresser in a cover, you can ask yourself whether it's reasonable for emergency personnel to see a knife on the ground out of its cover and say, I don't want to get cut. Let me put it away. Because Detective Stevens took nearly an hour to get there. He took his sweet time. He was alone. He walked into that room and he collected a very important piece of evidence. The state brought you some photographs, but they neglected to bring you this photograph. The photograph that Detective Stevens was forced to admit on the stand today was significant. He certainly went through a lot of trouble. Collected it at the scene. He brought it to the lab. He took it out of its cover. He took a photo. He submitted it for testing. All that work for something that had nothing to do with what happened that night. Use your common sense in evaluating that decision, members of the jury. How significant this knife was. Because it was significant to her. You know, she didn't shoot him in the back because she ran out of stories. She shot him in the back because she ran out of time. She didn't want to die. This is my last opportunity to speak with you, members of the jury. In just a few moments, State's counsel will have the final chance to argue, and that's a symbol. It's symbolic of the burden that they bear to prove to you, beyond and to the exclusion of each and every reasonable doubt, the elements of what they're claiming happened, and to disprove self-defense. I haven't done that today. Reasonable doubt has no size requirement. It could be the head of a needle or the size of a Mack truck. Today you had reasonable doubt. You saw it in the assumptions that were made by Detective Stevens. You saw it in the assumptions that were made by Dr. Crawford. You saw it in the lack of physical evidence. You saw it in the lack of statements. The state spent a good deal of time talking about Mrs. Rollins' first and second statements, and when you go back into the jury chamber, I am sorry to tell you, you won't get to see those statements. You'll have to take them at their word. You'll have to believe the detective who's filed false claims. You'll have to believe Dr. Crawford, instead of just providing you with the statements. Well, Mrs. Rollins explained the statements. She told you why she said what she said. Members of the jury, they're making this sound like this is a woman on the run. That she wants to obfuscate, she wants to blind you to what's actually happening. You know what she did. She went downstairs. She called 911. They read you the 911 call. She waited at a table with the gun in front of her. She waited for them to arrive. She didn't run. She didn't change her name. She didn't move to a different state, dye her hair. She stayed there. She went voluntarily 3 different times to speak to police, trying, through her mental disease, to explain what had happened. She's cooperated with 2 experts, 2 psychiatrists, and now she's asking you, members of the jury, to see that life or death situation that she was in, to understand the decision that she was forced to make. It was life or death, and she chose to live. That's not murder, that's self-defense. Find Mrs. Rollins not guilty. Thank you.
Your Honor.
Yes.
May I inquire as to my remaining time? Members of the jury, defense counsel just came before you and said this was life or death, and I can't disagree with that. Cinnamon Rollins had a choice. She could choose life for her husband, or she could shoot him in the back. And members of the jury, we know exactly what she did. Look, members of the jury, there are legitimate sufferers of domestic violence, legitimate people with mental illness in this world. The defendant is not one of them, and she does a disservice to those people. Members of the jury, she had a choice between life and death. She chose death, and I ask you to choose to find her guilty. Thank you.
I want to thank both the prosecution and the defense. And if you would just give the judges a few moments to tabulate our... We're going to remain in the courtroom while we do this. You can remain seated. And we're going to tabulate our ballots and then give you a few critiques while the ballots are being checked outside of our... outside. So you can remain seated if you want or congratulate each other, either one. The winning team is the prosecution. Congratulations.
Well, that's okay. Congratulations, University of Maryland School of Law. Congratulations, Florida, for being a finalist.
Maryland? Yes.
We have one more award to hand out, and we have one more award to hand out, and then we'll proceed.
And it's the best speaker. Is that what the title
correct.
is? The best speaker award, which the judges unanimously decided, is Mr. Nicholas Gurney.
Congratulations. Congratulations to Mr. Gurney and to the University of Maryland. This wraps up our 2015 Lone Star Classic. I'd like to extend a special thanks to our wonderful bench. As I was listening to the comments that they were giving each of you, I thought, wow, wouldn't it be great if we had the opportunity as more experienced lawyers to hear this from time to time, because this is invaluable advice. So relish in it. I'd also like to take a moment to thank our Lone Star Classic Committee. Professor David Schlueter has been the director of the committee for over 10 years, and it is his service to St. Mary's and the local community that ensures that this competition is the success that it is every year. Looking around the room, we have assistant directors Claire Strom, Rebecca Fisher, and Austin Griffith, who worked tirelessly since April to put on this competition, and Ms. Tiffany Figueroa, committee member and chair of the Board of Advocates. And I'd also like to thank the teams for your hard work. I know it took a lot of hard work, and you're probably exhausted by now, so congratulations. Thanks to everyone. If I could have the team.
You want us to come down here? Just. You're very welcome. Thank you very much. Thank you. Wow. Thank you. Y'all did a great job. You're welcome. You're very welcome.